Hi, we are discussing Rule 3, initiation of mediation, and in earlier clauses, clause 1 to 4, we discussed the earlier stages where how the legal service authority trying to communicate the information to the opposite party. So, under this particular fifth clause, when opposite party receives the notice under sub rule 2 and or 3, and opposite party wants some more time to appear before the authority, then authority can fix alternative date for appearance. That should not be more than 10 days from the date of the request. Even after the extension, if opposite party fails to appear, that is discussed under clause 6. So opposite party fails to appear even after extending the time, then the authority should submit the prepare a report in form number 3 specified in schedule 1 and endorse the same to the applicant and opposite party. So that is the form number 3, and content of form number 3 is like this: name of the applicant, date of application for pre-institutional mediation, name of the opposite party, date scheduled for appearance of opposite party, report made under rule 3 clause 4, rule 3 clause 6, then at the end non-starter report reason. So reason should be mentioned, then the signature of the authority, there it closes. So this is the non-starter report. Then coming to clause 7, where both parties to the commercial dispute appear before the authority and they give the consent to participate in mediation process, then authority shall assign this particular commercial dispute to a mediator and fix the date for their appearance before the said mediator. So authority will appoint mediator only after both parties appeared before the authority and given a consent, then only authority will appoint a mediator and also fix the date for their appearance before that particular mediator. Then clause 8 talks about authority shall ensure that mediation process is completed within a period of 3 months from the date of notice, from the date of receipt of application of pre-institutional mediation, unless the period is extended for further 2 months with the consent of the applicant and opposite party. So as you know, mediation is a speedy remedy where the settlement happens quickly compared to regular court. Hence, here in clause 8, authority shall ensure that the mediation process should be completed within the period of 3 months from the date of receipt of application. And if both parties are ready, given a consent, then it may be extended another 2 months. So 3 months, not general rule, and exception if both parties are agreed, another 2 months can be added. So 3 plus 2, within 5 months, this case the mediation process has to be completed. Then other rules, rule 4 talks about venue for conducting mediation. So premises of the authority, everywhere I am referring authority, that is legal services authority. So at the already at the beginning itself I mentioned, at the district level district legal service authority, state level state legal service authority, and at the national level national legal service authority. So accordingly that has to be interpreted. Then rule 5 talks about role of mediator. So mediator shall, on receipt of the assignment under clause sub rule 7 of rule 3, facilitates the voluntary resolution of the commercial dispute between the parties and assists them in reaching the settlement. What is the duty of the mediator once he is appointed to a particular commercial dispute by the authority? So he has to facilitate both the parties, and he has to mention that it's a voluntary process, and he has to facilitate both the parties so that, or assist them in reaching the settlement. That is the role of mediator. And rule 6, representation of parties. So what rule 6 says, party in person themselves can appear before the mediator. If not possible, then through his duly authorized representative or counsel. So personally, or duly authorized representative or counsel, any one of them, or together, they can appear before the mediator to discuss about the dispute and try to settle the matter. Rule 7 discuss about the procedure of mediation, how mediation procedure should be followed under this particular act for the commercial dispute. So clause 1, or we may call it as a rule 7 sub rule 1, the mediation shall be conducted as per the following procedure. These are the points, these are the procedure, these are the principles should be followed by the mediator. So at the commencement of the mediation, mediator shall explain to the parties mediation process. When parties appear before the mediator, mediator should explain how this mediation process starts, and during the mediation and at the end. So what is the procedure, and is it voluntary? So all those clarity should be provided by the mediator at the beginning itself to the parties. He should disclose that, he should clearly mention that, inform that it's not a mandatory to settle the matter through mediation. It's a voluntary process, and they can give their personal view in front of the opposite party, or separately, confidentially, he can discuss with the mediator. The date and time of each mediation sitting shall be fixed by the mediator in consultation with the parties to the commercial dispute. So which date, what time they should meet and discuss about the dispute. So that has to be decided by the mediator after consulting the parties. Mediator may, during the course of mediation, hold meetings with the parties jointly or separately as he thinks fit. So assume that I'm a mediator and two parties are sitting in front of me, and I will inform them about the process, and also I will tell them that if you want to share any information separately, not in front of each other, at any time you can request, and accordingly I will sit with you separately and view or hear your views. So that has to be clearly mentioned at the beginning itself, so that during the mediation procedure, whenever they feel, they can request to the mediator. Then next point is, the applicant or opposite party may share their settlement proposals with the mediator in separate sittings with specific instructions as to what part thereof can be shared with the other party. So here applicant or opposite party may share their settlement proposals with the mediator in separate sittings. This is important. So in separate sittings, for example, I am sitting with the opposite party, and opposite party shared 10 information. Out of 10 information, he instructed me 1 to 5 information should not be shared with the other party. So if that is the instruction of the opposite party in a separate sitting, then as a mediator I should strictly follow that. That is the trust, that is the confidentiality the mediator has to follow. Next point, the parties to the mediation can exchange settlement proposals with each other during mediation sitting, either orally or in writing. So it's a completely voluntary process. At any time parties feels that they can exchange settlement proposals with each other, so that one stage they can agree with each other. So it's a preliminary stage, they can share their proposals each other during mediation sittings, either orally or in writing. So full freedom is given to them. During the process of mediation, the mediator shall maintain confidentiality of the discussion made in the separate sittings. With each party, only those facts which a party permits can be shared with the other party. So in a separate sittings, they said some points you can disclose, you can share with the other party. Only those information should be shared with the other party by the mediator. So that confidentiality, what to share, what to not to share, instructions are given by the parties. So as per that instruction, maybe applicant or maybe opposite party, as per their instruction, strictly the mediator should follow. So these are all the points which a mediator has to follow during mediation procedure. Then next point, once both parties reach to a mutually agreed settlement, the same shall be reduced in writing by the mediator and shall be signed by the parties to the commercial dispute and mediator as per form number 4 specified in schedule 4. So mediator tried his level best to neutralize the mindset of the both the parties and convince them to settle the matter and convince them win-win position. Then ultimately both parties mutually agreed for the settlement, and whatever they agreed mutually, that has to be reduced in written form by the mediator, and that particular settlement document should be signed by the both the parties and the mediator as per form number 4 specified in schedule 1, which is given below. So that form number 4 settlement, this draft is made under rule 7.1, the 7, name of the authority and address. So here name of the mediator will be there, applicant, opposite party, date of application for pre-institutional mediation, venue of mediation, dates of mediation, how many, which dates they sit and discussed, and number of sittings and duration of sittings and terms of settlement. So these are all information should be mentioned in the settlement. And at the end, the date on which it has happened, both parties have to sign, applicant and mediator. and the opposite party. So all three people should sign that particular settlement document. So there is no need for mediator to write the history from day one till today, whatever happened, whatever both parties said in joint session or separate session, all those informations are not to mention in this particular settlement document. Only operative portion, terms of settlement should be mentioned. That is enough. The rest of the discussion, all those things, there is no need for mediator to mention in this document. The next clause talk about mediator shall provide the settlement agreement in original to all parties to the commercial dispute and shall also forward a signed copy of the same to the authority. So once the settlement agreement completes, then the mediator, he has to make settlement agreement in 3 sets. Here assuming 2 parties and are there, so 2 parties will get one original copy each, and a third copy should be forwarded to the authority. So the mediator shall provide the settlement agreement in original to all the parties to a commercial dispute and shall also forward a signed copy of the same to authority. Last point, where mediator tried his level best but no settlement is arrived at between the parties within the time specified in subsection 3 of section 12A of the Act, where the mediator is of the opinion that settlement is not possible, the mediator shall submit a report to the authority with the reasons in writing as per Form 5 specified in Schedule 1. So this clause, what it says, that even after trying maximum to convince both the parties for the settlement, but ultimately it is failed, then mediator has to submit the form number 5, that's a failure report. The content of failure report format is given, and that format contains as usual the name of the mediator, applicant, opposite party, date of application of pre-institutional mediation, venue of mediation, the date of mediation, and number of sittings, how many times they met and how many hours they sat and discussed, and reasons for failure. Then summary of reasons, not a detailed the report should be mentioned given here, just the operative portion on what reason this particular mediation is failed, so that has to be mentioned. And then again this failure report should be signed by the applicant and opposite party and the mediator. So these information should be filled and submit to the authority. Then the clause 2 talks about the authority or the mediator, as the case may be, shall not retain the hard or soft copies of the document exchanged between the parties or submitted to the mediator or notes prepared by the mediator beyond a period of 6 months. So here it is also duty of the mediator or the authority, as the case may be, they should not keep hard or soft copies of the documents exchanged between the parties, not a settlement agreement. Settlement agreement can be kept permanently and that can be shared wherever it is needed. But the 3 months or 5 months, whatever exchange has happened, hard copies or soft copies. So those copies, they can, prepared by the mediator beyond 6 months, other than the application made under different thing. So he cannot keep all those documents not more than 6 months. So whatever documents are there. Then rule 8 talks about parties to act in good faith. Always the parties to the commercial dispute should participate in good faith. Mediator is appointed by the authority, and the authority has also responsibility, and on that basis good mediator is appointed, and party should participate with good faith. Then only settlement can be possible. So that is the rule 8. Rule 9 talks about confidentiality of mediation. So already I have discussed on this point. So this rule 9 directly talks about on confidentiality. The mediator parties, their authorized representative or counsel shall maintain confidentiality about the mediation, and the mediator shall not allow stenographic or audio or video recording of the mediation sittings. So this is prohibited. What is prohibited? Stenographic or audio or video recording of the mediation sittings cannot be done. So that much confidentiality has to be maintained. Rule 10 talks about maintenance and publication of mediation data. So the applications are made for mediation to the authority. Authority refers to the mediator. Mediator submits successful mediation agreements and failure agreements or failure report. So in case of district legal service authority shall forward the detailed data of the mediation dealt by it under the act to the higher authority, that is state legal service authority. Similarly, state legal service authority shall maintain the data of all mediations carried out by it or under its jurisdiction, and publish the same on quarterly basis on its website as per form number 6 specified in the schedule 1. What is form number 6? It is given below: the name of the authority, name of the applicant party, name of the opposite party, number of application slab wise as per schedule 2. So all these details should be submitted quarterly to the higher authority. So this is the rule 10. Rule 11 talks about mediation fees. So under this particular rule 11, the party who wants mediation, who files application for mediation, he has to pay the one-time mediation fee. So before the commencement of the mediation, the parties to the commercial dispute shall pay to the authority a one-time mediation fees to be shared equally as per quantum of claim as specified in schedule 2. So schedule 2 is given here mediation fees. So here quantum of claim in one column and fees is another column. So from 3 lakh to 10 lakh, 15,000 rupees is the fees, and 50% of 15,000 should be paid by each of the parties. because parties should share the fees equally. Similarly, the other quantum of claim and proportionate fees as prescribed in Schedule 2. So, before the commencement of the mediation, this fees has to be paid to the authority under as per the Schedule 2, that has to be paid. Then Rule 12 talks about ethics to be followed by mediator, because ultimately mediation is successful, or mediation um, alternative method will be uh, get publicity when the mediator follows ethics, and public will trust mediation procedure, and more number of people will approach mediation centers to settle the matter outside the court. So Rule 12 talks about ethics of the mediator. So mediator shall uphold the integrity and fairness of the mediation process, and ensure that the parties involved in a mediation fairly informed and have an adequate understanding of the procedural aspects. So everything should be well in advance informed to the parties. Disclose any financial interest or other interest in the subject matter of the commercial dispute. Mediator has to disclose at the beginning itself if he has any financial interest or other interest in the subject matter of the dispute. So that has to be disclosed. Then avoid any impropriety while communicating with the parties to the commercial dispute. Then be faithful to the relationship of trust, confidentiality reposed in him. Then conduct a mediation related to the resolution of commercial dispute in accordance with the applicable laws for the time being enforced. So these are all uh, ethical rules should be followed by the mediator. Further, recognize that the mediation is based on the principles of self determination by the parties, and mediation process relies upon the abilities of the parties to reach voluntary agreement. Then refrain from promise or guarantees of result. When you take when you appointed when a person appointed as a mediator, and in first meeting with the parties, he should not give guarantee promise that within a month it will be settled. I am giving you assurance. Those without undergoing the procedure at the beginning itself, the mediator should not give promises or guarantees of results. He should avoid those things. Not to meet the parties, their representatives, or their counsels, or communicate with them privately except during mediation sittings in the premises of the authority. Why it is mentioned? Because if our mediator meets one of the parties separately, and other party, if other party saw that particular meeting, then he suspect the mediator's integrity. That's why this particular point says not to meet the parties, their representatives, their counsels, or communicate with them privately except during mediation sittings. So that has to be maintained. Not to interact with the media or make public the details of the commercial dispute case being mediated by him, or any other allied activity carried out by him as a mediator, which may prejudice the interest of the parties to the commercial dispute. So here, mediator knows in and out of the dispute what the parties' view, because the parties have shared the information confidentially. So that particular information should not be disclosed or interact with the media or make it public in any mode. That is prohibited. So that is also one ethical uh, rule of the mediator. So this is about the procedure and how the mediation process happens under section 12A of Commercial Courts Act. So this is the procedure.